Hi everyone, my name is Chen. I'm currently a postdoctoral research fellow at National University of Singapore Faculty of Law. It is my great pleasure to be invited to present my work at this year's CIBEL Global Network Young Scholars Workshop. The topic of this year's conference and workshop is digitalization, sustainability, and beyond. And my research explores the intersection between renewable energy transition policies and international investment law and arbitration. And therefore, my work fits well with this year's theme, and I appreciate that CIBEL organized this exciting conference and workshop for us to discuss these trending topics within the international community. So the title of my work in progress research paper is Legal Stability and Renewable Energy Transition Towards More Deference to Regulatory Changes. To start with, what does renewable energy transition mean? So it refers to the general trend of replacing traditional ways of energy production and consumption, which are basically based on fossil fuel, to replace fossil fuel with clean and zero carbon energy sources like solar, hydro, and wind, etc. So since the UNFCCC and the Kyoto Protocol, many countries implemented domestic policies to attract investment in power plants based on renewable energies. And they generally provide attractive financial and tax incentives to these investors. An important reason to grant these incentives is that the cost of establishing power plants based on renewable energy can be very high at the beginning. This will consequently make the electricity price generated from renewables high on the market and make those investors at disadvantages the state in the market. The measures that are commonly used by states to provide financial incentives and tax incentives include feed-in tariff, feed-in premium, green certificate, and tax exemption, etc. The details of these measures vary greatly, but they have the same underlying logic, and that is to make sure that the investors can sell their electricity at a price higher than the market price, and therefore maintain the profitability of the operation of those power plants. And these policies have been quite effective in boosting investment in renewables. However, with the rapid increase of like PV plants and wind plants, states find that they have to make adjustment to these RET policies. There are mainly three reasons. The first is that with the increase of power plants, the state has to provide a larger amount of financial incentive to investors, and this has caused a tariff deficit of some countries like Spain, and this can also cause the increase of electricity price on the end of consumers. And secondly, the governments may overcompensate some renewable energy based plants and therefore cause unnecessary market distortion. And thirdly is the decrease of cost for renewable energy electricity suppliers. As this graph by the International Renewable Energy Agency shows, in the past decade, the global levelized cost of energy from newly commissioned utility scales renewable power generation technologies, especially those relating to solar PV and wind, has dropped dramatically. It thus gives rise to the question of whether it is still necessary to provide high amount of financial incentives to operators of this power plant. And therefore, states have adopted measures to either repeal or modify the financial or tax incentive regimes to these investors, which has unsurprisingly caused a large and increasing number of investment arbitration cases against them. The vast majority of these ISDS cases are under the Energy Charter Treaty, and a key provision relied upon by these foreign investors is Article 10, which requires host states to encourage and create stable, equitable, favorable, and transparent conditions for investors. And it also requires the host states to accord at all times to investment of foreign investors fair and equitable treatment. If we look at the development of ISDS jurisprudence, we can see that it has been a tradition for investment tribunals to interpret fair and equitable treatment as including the obligation to provide a stable regulatory framework. As early as the Metalclad and TechMet cases, the tribunals found that investors' legitimate expectations include an expectation of a consistent or transparent or stable legal framework. And this approach has been adopted by numerous later investment tribunals in their interpretation of fair and equitable treatment. This interpretation is clearly very broad. Therefore, some later tribunals like San Luca or Continental tried to construct a more balanced and contextual approach, which highlight host states' regulatory rights. At the same time, investment tribunals' interpretation of the obligation of legal stability is far from consistent. They have reached different understandings, conclusions regarding whether legal stability is a freestanding obligation or it is part of fair and equitable treatment, or whether the host state bears a general obligation of legal stability, even if it has not made any prior commitment. And what constitutes specific commitment? Does a general legislative or political statement constitute specific commitment, or it has to be a more individualized or personalized commitment? And last but not least, how to assess the host state's margin of changes in light of the obligation of legal stability. In my paper, I take a closer look at the disputes against Spain because they constitute a fascinating case to observe how investment tribunals have been interpreting the same treaty provision differently in light of basically the same regulatory measures. Up to now, there has been over 50 ISDS cases related to RET against Spain. During 1997 and 2007, the country implemented a series of measures which offers investors in renewable energies feed-in tariff that is a guaranteed fixed above market price offered to these electricity producers. However, due to the electricity tariff deficit, the country modified the remuneration framework in 2013 and 2014 by replacing FIT with a market-based specific remuneration, which significantly reduced the amount of financial incentives investors can receive. When analyzing whether Spain's regulatory changes have violated the obligation of legal stability, as this graph shows, investment tribunals generally consider a broad range of factors. And as I will explain in my paper, and I will present during the workshop, I have categorized investment tribunals approaches into three types. The first is the fundamental change approach. The second is a reasonable change approach. And the third is legitimate expectations in a strict sense. So under this approach, investment tribunals distribute different weight to these different factors. So after a review of the relevant cases, it is safe to conclude that there's a general trend of the development of the jurisprudence towards a narrow interpretation of legitimate expectations and legal stability. And I have three preliminary arguments relating to investment tribunals' approach to RET related policies and legal stability. The first is that the link between fair and equitable treatment and a general obligation of stability appears to be overreaching because they originates from the overly broad interpretation of legitimate expectations in earlier ISDS jurisprudence. And the second argument is that proportionality analysis can be a tricky tool to analyze host states' margin of changes. And many tribunals adopted this approach. And I argue that for polycentric issues like RET, more deference should be granted to the host state because in most times, RET policies are highly complicated and in most times, states implement the changes to those policies with good intention. And also, the overall objective of the Energy Charter Treaty is not only to protect investors' rights, but also to respect the energy sovereignty of host states. And thirdly, when interpreting treaties that do not explicitly refer to stability, so unlike the Energy Charter Treaty, tribunals might focus on specific commitments and fundamental principles of the rule of law, like non-retroactivity. So these are some a bit detailed explanation of my research project. And as I mentioned, it is still work in progress. And so I look forward to discussing those findings and the preliminary arguments at next month's workshop.